According to the chairman, Nigeria Bar Association in Ondo State, Dan Olawale, the reasons being put forward by defenders of the CJN are fallacious. For him, an offence can only be reported and tried when discovered. The CJN must be prepared to face and stand trial. Let us allow the rule of law and not the law of rulers. Justice Walter Onnoghen is just another Nigerian who should subject himself to laws that govern all Nigerians. Now let's take a look at provisions of the Constitution on issues like this. Schedule 5, Part 1 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provides in paragraph 11, Section 1, subject to the provisions of the Constitution, every public officer shall within 3 months after the coming into force of this Code of Conduct or immediately after taking office and thereafter at the end of every 4 years and at the end of his term of office submit to the Code of Conduct Bureau a written declaration of all his properties, assets and liabilities and those of his unmarried children under the age of 18 years. 11 subsection 2. Any statement in such declaration that is found to be false by any authority or person authorized in that behalf to verify it shall be deemed to be a breach of this code. The same law provides that no public officer shall maintain any foreign account. These include Chief Justice of Nigeria, Justices of the Supreme Court, President and Justices of the Court of Appeal, all other judicial officers, and all staff of courts of law. Paragraph 12 of Part 1 of the 5th Schedule to the 1999 Constitution provides, 12. Any allegation that a public officer has committed a breach of or has not complied with the provisions of this code shall be made to the Code of Conduct Bureau. And now, constitutional lawyer Kennedy Osunwa joins me to discuss this. Thank you, Barrister Osunwa.
Yes, good afternoon, and good afternoon, Nigerians.
Now, let's examine the position of the Nigeria Bar Association, chairman of the NBA in Ondo State, whom I quoted earlier, and placed side by side with the provisions of the Constitution that I just read. So, can you interpret it for us? Is there anything that is at variance?
Well, the issue is that it's unfortunate that this matter is coming up this time when Nigeria is preparing for another democratic elections. However, the law must be obeyed by all sundries, no matter who is involved. But in obedience to that law, remember the provision of the Constitution that says that an accused person is deemed innocent till the contrary is proved. Now there is an allegation of non-compliance with the provisions of the law, particularly Section 15 of Code of Conduct Tribunal Act, which goes to provide, among other things, the declaration of assets and all that. However, having said that, it suffices to state that every citizen of Nigeria is compelled to obey the law. And once the law has been seen reasonably to be disobeyed by a citizen, then there will be investigation into that matter. When you also look at Section 158(1), it says that a matter that has in a situation where a public servant like the CJN this time around has been found wanting, who is a judicial officer, by the incursion of that, the investigation has to be directly done by NJC, the National Judicial Council. So now, if you are saying that the CJN has disobeyed this law or he is not in compliance of this law, fine. But the right body must investigate it and then give recommendation. After such recommendation, then either the Code of Conduct Bureau will now act on the recommendation of NJC. So
now the petitioner is latching on to the allegation, quote and unquote, titled unlawful enrichment. Is unlawful enrichment outside of the provision of that section of the Constitution that states that when that judicial officer is in breach of the judicial oath? Is it outside of the judicial oath?
Well, no.
Does it fall under fraud, financial misappropriation, and all of that?
It falls under non-compliance of
judicial oath.
Judicial oath.
Okay.
Of office. Okay, but
so the petitioner is mischievous.
However, like whatever the petitioner, anybody can petition anything, but the substance is what we are talking about. And in order to determine the substance, what we are saying is, has that allegation been thoroughly investigated? Okay. Bearing in mind that the person involved is #1 judicial officer in Federal Republic of Nigeria. And bearing in mind again the omnibus section of Section 36 of 1999 Constitution as amended that presumes innocence of an accused person. Therefore, you cannot immediately nail the CJN as somebody that has not complied. For instance, the proviso you read, you must, as a public officer, not to operate a foreign account. Okay, that law, it is still investigation, and once it's before the court, that the court will determine whether the CJN has operated foreign account. The context of domiciliary account, domiciled in Nigeria, and the foreign account, domiciled outside Nigeria. Do you understand?
But then again,
it's a different.
But then again, Barrister Osunwa, the CCB is a judicial institution, just as the chairman MBA Ondo State, who is saying that an offense can only be prosecuted when it has been discovered, is a judicial officer. So aren't lawyers also creating some form of confusion in the interpretation of the Constitution?
There is no confusion. All depends on the interpretation of the law. And of course, it is the judiciary and the court.
But when we have more than one interpretation of the law,
then the court will give a final interpretation to you. But what we are saying is this. We are not saying the chairman of that MBA of that branch cannot really say, okay, CJN has committed that offense. You cannot, because the Constitution has deemed him innocent till the contrary is proved. And of course, you see, the court, the litigation in court has started. They served him summons. And again, don't forget that every originating summons or originating processes of court must be personal service. It must be served directly, not by aides, unless if there is a court order to that effect. And again, the CJN again is challenging the jurisdiction of the court. So it is non-service challenging the jurisdiction of the court, which means unless the issue of jurisdiction is determined, nobody will ask CJN, oh yeah, go.
Okay, very quickly, what do you make of the prosecution's position that he should be present in court before objections can be raised as to the authority of the court to try?
The question is, if you want the CJN to be present in court, have you served the CJN? The court processes must be served on him. And the rule is that every originating processes must be served personally.
Not by proxy.
Not by proxy. If it's going to be by proxy, then there's going to be an application that will be brought before the Honorable Court, upon which the court we make a pronouncement or an order for that originating processes to be served by proxy instead of personal.
All right,
so unless this condition is fulfilled, the prosecution cannot say, oh yeah, come. Where is he going? What is he going to do? It is except he is served in accordance
with the law. Barrister Osunwa, thank you very much for your time and your contribution to this conversation.
Thank you very much.